Good morning. Today we are going to discuss again the mental element in tort, but some different aspect. In the last lecture we have seen intention and malice as a mental element in tort, whether it is required or not. We have seen that malice or motive is sometimes required. Sometimes in some tort it is required. Otherwise, it is not an essential element. In general tort, it is not an essential element. Then we saw about intention. Intention is also not essential in tort. A lawful act will not become unlawful only because intention is there. Similarly, you can take it opposite also. An unlawful act is an unlawful. The person may have intention or he may not have. We don't consider in tort. In tort, the main thing is there must be a legal injury. So, two things or two elements we have seen, and both these elements are not required in tort. Tort law considers the damage caused, the legal injury caused, and it tries to give the solution. It tries to give compensation. Now, other concept is there which is called as fault, a faulty element in tort. It's very much required. When a plaintiff files a case against the defendant, he has to prove that the defendant had a fault, the defendant was faulty, and such a defendant is not in a position to give proper justification. The plaintiff is going to win the case. So, fault must be proved. Fault of the defendant is a very essential element. Okay. Now, this is a simple concept then. The plaintiff has to prove the fault of the defendant, he'll get justice. However, nowadays what has happened, we have brought a new concept called as no fault. Okay, when we say, okay, the defendant is faulty, make him liable. Now again we are changing our position and we are telling, no, sometimes the defendant is liable on no fault basis. Means here the fault of the defendant will not be seen, or he may not be faulty also, but he'll be liable. Okay, means here two extreme things are there. The first thing is proper, that defendant is faulty, he must be liable. Now the other thing is there, that the defendant is not faulty, but he'll be liable. Means in these two extremities, law is there telling about certain things, and that is based on the public policy, the objective of law. See, now in accident cases, many accidents, motor vehicle accidents are occurring. Therefore, in law we have brought a concept called as no fault liability. Means the dependents, they will have full right to get certain amount of compensation on no fault basis. So these two things, just opposite things are there. You are telling at one time that prove the fault and get justice, and in other time you are telling no fault of the other. There was no fault of the defendant, but he'll be liable. Here what the objective of law is, that public policy requires, public interest requires that this person should be made liable. The concept of strict liability states that if public policy is there, then we have to make him liable. We should not consider the fault of other. Okay, now in intention also I had told you one case, that was the balloonist case. We'll take one another case, that is of actually the case is of nervous shock, Wilkinson versus Downton. This case is based upon a certain practical joke. What the person does, what the defendant does, he goes to the plaintiff's house. She is his friend's wife. He enters the house and tells her, "Arey, your husband, whom I saw just now in a car, he has met with an accident." He told her it as a practical joke. But what happened? She faced a shock. It was a nervous shock. Before this case, nervous shock was not discussed much in tort. From this case, nervous shock became a tort. She filed a case. She became unconscious. She was hospitalized. She had to spend money. And when she got the consciousness, she saw that her husband was in a proper condition. She filed a case against the friend that what you have done, because of you, I have to face such a legal injury and all. I have to face such a damage. I have to do the expenses. And shock occurred to me. In that case, or in the books, it is mentioned like they have to show the extreme shock she felt. Therefore, they have the phrase called as, when the friend told her that her husband has met with an accident, her hair turned white. It is just a phrase to show how much she faced the shock. In this case, the defendant is telling, okay, I was just joking. I was not having any intention. I was not having any malice against you. It was just a practical joke. But what law says here? Law says when you want to make a joke with the other, that you should know your limits. You should know the repercussions. You should know the consequences of your act. You may call it as a joke, but the other person may face such a shock. So you are liable. Okay, now this was a practical joke, but it was a it was a joke which was made at a wrong time and to a wrong person, a very much sentimental person who faced a shock. He was liable. He had to pay compensation to the plaintiff. We consider here some fault of his, isn't it? He should not have done this. So he was faulty. He should be made liable. This is proper. He was faulty. He got the plaintiff got the compensation. But in certain cases, no fault will be seen. No fault. He may not be faulty also, but he'll be liable. We'll take an example of environmental laws. In Public Liability Insurance Act also, we are having a provision that on no fault basis, compensation must be given. Under environmental laws, if the occupier of the factory or the owner of the factory, they don't follow the rules and regulations which are meant for environment, they are liable. Okay, you will say, ma'am, but they are liable only because they are faulty. Yes, they are faulty, but there is a concept as no fault liability. No fault liability. Here the fault will not be seen. They may be faulty also, they may not be faulty also, but they are liable. Now, not only liable for the workmen in the factory, they are liable for all the public. You should not see here the faultiness of the defendant. They are liable because law puts here strict liability. Public policy requires that the defendant should be made liable. Whenever a person is having a manufacturing process which is hazardous means which is going to affect, risk is more there, which is going to affect the environment, which is going to affect the human life, where chemicals are used in the manufacturing process, that is called as hazardous. Now, in a hazardous process, anything happens, any accident occurs, the manufacturer will be strictly and absolutely liable. Fault will not be seen. We will not go to see the fault also. He'll be liable on no fault basis. So compensation will be given. So these two things are extreme. You are faulty sometimes, you are liable. Law will see whether you are faulty or not. But sometimes law requires that this person should be liable. This person should be strictly liable, absolutely liable, because public interest requires, because public policy requires. In that circumstances, the intention, the fault will not be seen. He will be strictly liable. In these two extreme positions lies the rules of law. So, in the concept of mental element in tort, we discuss these three aspects. One is motive, the other is intention, the third is fault and no fault liability. Okay, getting it? When you study law, you have to study with dedication. You discuss with me for 10 minutes, but you have to put time and read books, recommended books. In the description box, I will give you the names of the authors, the books which you have to read. Okay? Bye bye. See you in the next video.